I have now been a Superior Court judge for over 13 years. During that time, I have handled many contested sentencing hearings. Because of the circumstances, unique circumstances of this case, I can assure counsel, the defendant, members of the family, law enforcement involved in this case, that I have spent many hours thinking about what an appropriate sentence should be given this case. But before I get into what my sentences will be imposed in this case, and a little bit more about my reasoning behind those sentences, I want to take a moment to acknowledge three people: Kassandra Sweeney, Benjamin Sweeney, and Mason Sweeney. I want to thank the state for presenting some images from the day of the homicides, not the photos which I've seen, but photos and videos depicting Kassandra, Benjamin, and Mason in life. What is evident from those photos and from the remarks from the family and friends today is these were three wonderful people. People who were happy, joyful, loved each other. And I can tell from each of you who spoke today the depth of the loss, but also what their lives meant to you. As a judge, I don't know, never met Kassandra or Benjamin or Mason, but I do feel like from the videos, the photographs, and the discussion from members of the family today, I at least had a snapshot of who they are. And that's all it is, a snapshot. But I can, watching the reactions of all of you today, I know that their memories are carried with you forever, and the pain and suffering is also something that will last for the rest of your lives. And I didn't think it was appropriate to talk about the sentences before acknowledging that each of them mattered. Kassandra, Benjamin, Mason, each of them mattered a great deal. And I appreciate hearing from each of you about that and what they meant to you. And I've thought a lot about that as well. Two things are very clear in this case. First, Mr. Sweeney, Eric Sweeney, the defendant here, had a horrific early childhood marked by physical, sexual abuse, and severe neglect. Second, the murders of Kassandra, Benjamin, and Mason were unimaginably brutal and heinous. A young mother, 25 years old, with her children aged 4 and 23 months, playing, just enjoying a typical day. Not a holiday, just a typical day. Costumes, seeing an animal out the window. That is a typical day that a family should be able to enjoy. When the defendant, with no provocation, no justification, no thought or care for the consequences of his actions, savagely slaughtered each of them by shooting them, leaving their bodies on the floor of the home they shared with him, that they welcomed him into when he had no place else to go. What an act of love and compassion for somebody who is suffering, to welcome them into your home. To cover for his own despicable acts, the defendant fled the home and got rid of the gun. It is very hard to reconcile those two things. A child who suffered like a child shouldn't suffer, and I accept the representations about the terrible childhood that Eric Sweeney had, and the awful nature of his crimes. It's something I've thought a lot about, and I don't know that anybody has a definitive answer to reconcile those two things. I can only assure you that I'm doing my best to determine what is fair and just, considering all the circumstances. In any case involving sentencing, there are considerations of punishment, general and specific deterrence, and rehabilitation. These principles have been refined by case law from the U.S. Supreme Court and our own state Supreme Court in the context of a person who was under 18 at the time of the commission of a murder or murders. In Miller versus Alabama, a case that both sides have talked about, the U.S. Supreme Court ruled that the Eighth Amendment to the U.S. Constitution prohibits mandatory life in prison without parole for a juvenile offender convicted of homicide. Importantly, Miller did not preclude such a sentence, but only that the sentencing court must consider an offender's youth and attendance characteristics before imposing sentence. After the Miller decision, several offenders in New Hampshire, and there was discussion about them, who had received mandatory life in prison without possibility of parole, were resentenced. There's discussion about a number of those people, and I'm familiar with the circumstances of those cases. Our state Supreme Court in State versus Lopez held that a 45-year to life sentence under which the defendant had the opportunity to be considered for parole when he is 62 years of age was not a de facto life sentence under the Eighth Amendment. Our court quoted extensively from the Miller decision. And one thing that is clear that the court decisions all recognize is the difficulty of determining when somebody is beyond the hope of any redemption and whether or not their circumstances are such that they can be rehabilitated. That is a difficult determination to make. Extremely difficult when we're talking about someone who commits a horrific crime when they're 14, 15, 16, or 17 years of age. And I can't say that here on October 3rd of 2025 that I have a definitive answer to that question either. These are things that are not knowable by us today that will take the course of decades to determine over the course of the next 10, 20, 30, 40 years and beyond. Is, at this moment in time, the defendant beyond any hope? Or is there some possibility that he can be redeemed and rehabilitated? I don't know the answer to that question. And I listened very, very carefully to the arguments from both sides about this. And I want to say that I appreciate the quality of the advocacy from both the state and defense in this case. These are excellent lawyers who made their cases very well and made my job all the more difficult by the quality of the work that they've done. But I read their memos carefully, I read the attachments carefully, I listened to the evidence that was presented, and I've thought a lot about this. But the language in the Lopez decision from our court goes to the core of the sentencing struggle in this case. How to distinguish right now in 2025 with a 19-year-old defendant before the court whether he is that person who can never be redeemed or rehabilitated, or whether he is somebody who can be rehabilitated. The state's proposed sentence no doubt fully reflects the magnitude of the crimes and is completely understandable, considering the loss caused by the defendant's horrible acts. These are three separate people, Kassandra, Mason, and Benjamin. Three lives that were valuable and important, an immeasurable loss to their families and to society. There are many more people than the people who are here today who are affected by the losses of these people. I know that we could probably fill many courtrooms, maybe a stadium, with people who could speak to the value of those people. The state's recommendation, I completely understand where they're coming from. Likewise, I believe the defendant's recommendation accounts for the tragic circumstances of the defendant's childhood before he was taken into Sean and Kassandra's home. Both sides present well-reasoned arguments reaching very different conclusions. As I have thought about this, I have felt and come to the determination that a sentence short of life, providing the defendant a very tight but narrow path for which he can achieve redemption at some distant time in the future, is appropriate. My sentence that I'm going to be issuing today, in my view, reflects the magnitude and the nature of his crimes, but also provides a path for the defendant, a difficult path for him to achieve some measure of redemption and rehabilitation and some hope of someday walking out of the prison walls. Rather than imposing consecutive sentences on each of the offenses, I have concluded that a very significant sentence that will be greater than any sentence ever imposed short of life for somebody convicted of homicide after Miller and the Miller people, but which provides the opportunity at some very distant time in the future to possibly achieve parole and release, recognizes what we know now versus what I cannot know now. And I cannot know now what the defendant will do in the next 20, 30, 40, and 50 years. That will be up to him, and if he fails to do that, I have no doubt, hearing from the Southwick and Sweeney families today, that there will be people showing up to speak loudly and firmly why they are opposed to anything short of him remaining behind bars. This is not going to be lost in the memory of anyone in this courtroom. But I believe that a path to achieve that at some distant point is appropriate. The goal that I have been trying to achieve in the sentences that I will be imposing today is to hold the defendant accountable while providing for the possibility for release if he can demonstrate that he's truly rehabilitated, reformed, and someone who can be trusted. That's a big lift. That's going to take not a week or two or a year or two of being of good behavior, but decades of that. The sentences that I'm going to impose on all 3 homicide charges will be 60 years to life, concurrent on each, with a possibility of 3 years of the minimum sentence suspended if the defendant completes high school, a high set, or GED or equivalent, and an additional 3 years suspended if he completes a vocational program approved by the Department of Corrections. By my math, this means that if he does both of those things, he could be before the parole board when he is 70. That is 54 years from the time of the crimes. 70 years of old, if he does those things. If he avails himself of all the possible earned time reduction under RSA 651-22A, 22A, there's a possibility that he may get before the parole board a little bit after he turns 68. That is a tight and narrow path that he must pursue in order to achieve the possibility of release in more than half a century. That is the earliest time under the sentences that he could be before the parole board. A little over half a century from now. If the defendant is a behavioral problem, engages in gang activity, commits further acts of violence, or fails to take advantage of the educational, mental health, and vocational and rehabilitative programs at the prison, he will have by his actions shown that he deserves to spend every waking moment for the rest of his life behind bars. He will lose that opportunity for release at some point. Again, this is a narrow path that takes him nearly to beyond the point of life, or to the point of life expectancy within just a few years of the point of life expectancy for males in this country. On the other hand, if he takes advantage of his opportunities, does not engage in gang activity over decades, 50 years, does not engage in further acts of violence, and shows that he has become aware of the consequences of actions and demonstrates that he's truly rehabilitated and reformed, he'll have the opportunity. Again, he'll be older than I am right now. He'll be older. He'll be at the age that many people are retiring. 70 years of age. I have no doubt that many would argue that that sentence is not consistent with the New Hampshire Constitution or federal Constitution, but I believe, looking at that case law, that given the magnitude and seriousness of his offenses, that a sentence shorter than that does not fully recognize the depth of his actions. Again, a narrow opportunity only if he takes full advantages of what is provided to him. So on charge ID 2348002, a finding of guilty is entered upon the defendant's plea. He is sentenced to New Hampshire State Prison for not more than life, nor less than 60 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence, to be prorated for any part of the year. He has pretrial confinement credit of 1,185 days. The sentences stand committed. Further, the defendant shall pay restitution of $29,290.88 to victims' compensation. Restitution shall be paid through the correctional facility or Department of Corrections as directed by the probation parole officer. A 17% administrative fee is assessed for the collection of restitution. The defendant is to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation parole officer. Subject to the provisions of RSA 651A 22A, the Department of Corrections shall have the authority to award the defendant earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence or return it to its rightful owner. The defendant is ordered to be of good behavior and comply with all terms of the sentence. 3 years of the minimum sentence shall be suspended for completion of a high school diploma or high set or GED or equivalent. 3 years of the minimum sentence shall be suspended for completion of a vocational program approved by the Department of Corrections. The defendant shall not profit in any manner for his role in committing these offenses, nor may he assign his rights to any monetary profit or financial benefit to any other person. Specifically, he may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murders of Kassandra Sweeney, Benjamin Sweeney, and Mason Sweeney, or to the defendant's actions therein. On charge ID 2348003, this is identical and concurrent in all respects except with regards to the restitution, which is only applicable to the first charge. As to charge ID 2348004, this is also identical and concurrent in all respects with the exception of the payment of the restitution that applies to the first charge. Finally, on charge ID 2136113, the charge of falsifying physical evidence, a finding of guilty is entered. The defendant is sentenced to New Hampshire State Prison for not more than 7 years, nor less than 3.5 years. All the minimum and all the maximum sentences suspended. Suspensions are conditioned upon good behavior and compliance with all terms of this order. A suspended sentence may be imposed after hearing at the request of the state. The suspended sentence begins today and continues for the duration of the defendant's life. The sentence is consecutive to the sentences that I just read. Further, the defendant is to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation parole officer. The same provision of RSA 651A 22A applies to this offense. The Department of Corrections shall have the authority to award the defendant earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. law enforcement agencies may destroy the evidence or return it to its rightful owner. The defendant is ordered to be of good behavior and comply with all terms of the sentence. The defendant agrees to have no contact with Kassandra Sweeney's family, including Kristen Southwick, Terrence Southwick, Katrina Southwick Turnbull, and he shall have no contact with Sean Sweeney. Further, the defendant shall have no unsolicited contact with any member of the Sweeney family other than with his mother, Heidi Sweeney. And again, the no profit condition, the same language applies to this offense as well. I recognize that there are many people who feel like this is not justice, given the loss of these 3 lives. I get it. I listened to you all very carefully. The pain was raw and real, and I 100% understand. In reaching the sentences that I have done, I have tried to balance all the considerations of sentencing here, thought about the circumstances, and provided a narrow path. I'm sure that Eric Sweeney is sitting there and his counsels feel that this is a sentence far in excess of what they had hoped. I have tried to balance those things to give him that narrow path. What happens at this point going forward will be up to him. I wish all of you peace. I get it, and I appreciate you all being here, and I listened very carefully to what each of you had to say. And please know that I will not stop thinking about Kassandra, Benjamin, and Mason. I was blown away by what you all had to say. And Mr. Sweeney, again, this is a narrow path. I hope that you show through your actions that you are worthy of the opportunity. And it's not much of an opportunity, but it is something. It is a hope. And it's my hope that your actions going forward demonstrate that you are worthy of that. That will be a determination that, as I said, is not knowable right now. That will depend on your actions over the course of the next 20, 30, 40, and 50 years. It is up to you. If you truly take responsibility, you will demonstrate that you are worthy of that opportunity. I hope you do that, and I hope that the family has peace. Thank you all very much.
All right, the court.